2023. Mr. R. Dhor. This is with regard to non-release of your legal fee. 23.
Sorry, my lord.
No,
I'm not engaged in this.
29, Likasan. On the prayer of the learned counsel for the petitioner, for an adjournment in the matter on account of personal inconvenience, the matter stands adjourned, registered to list this matter after 4 weeks on a date to be fixed by. 23, we'll pass orders when the matter reaches.
Maybe. My lord, item number 10, maybe my lord taken after vacation number. It is some part of personal.
Wait.
My lord,
Why?
my lord,
Be here. Let the matter be called.
May I please, Your Lordship, I beg to mention item number 13. Lordship.
1 3,
Pass. 13, 1.
rejected.
Password 1.
Rejected. 13, prayer rejected. If you want to do the matter, or we'll pass orders.
Lordship.
Yes. Any more?
Lordship, another prayer is item number 17. Lordship,
Huh?
forward. Item number 17, Lordship.
Huh.
Forward to the petition, Lord. I am appearing from on behalf of N. Ahmed, Lordship.
Qazi appointment. Call him. That act is no longer there. So what is the matter? What is the fun in keeping this matter pending? You challenge the act.
Lordship, the matter is infectious.
Can't help it. No adjournments. Be here when the matter is called. Don't ask for an adjournment just for the sake of adjournment. If you had some genuine problem, we will not read. Give a adjournment slip. We come reading, and I'm not adjourning. You be here. Yeah, Mata.
Item 1.
Only Altoni will go say that. Yes, who is appearing for the petition? Time being. We'll have it. Let him come. Yours is not a compassionate appointment. Your case that there was a selection process, right, wrong, you were appointed in Pearl. And the directors is supporting you in that matter, to that extent.
This is the in the year 2005, there was this grade 4
But his
appointment.
case is in
Right.
2005, there was no vacancy. The vacancy arose in 2006. What do you have to take on that? If that selection is of 2005, it was against a non-existent post.
After the vacancy, I think it's a selection. has been
Be
done.
that as it may, while advertising, they advertised it for fun, that the man will die in 2006.
No, that is
Then-
not the
Then, what is your take on that? Just clarify your issue on that. After some time.
Item 2.
petitioner is paying for her arrears salary, my lord, from 27 to
Yes, Mr. Katonia, what have you done? You were supposed to incorporate that in the budget of 2024-25. Now that is gone, the fresh budget has also come.
The latest instruction, my lord, today I don't have, my lord.
Hmm.
Although our earlier proposal was sent and there was some discrepancy, so it was rectified.
Hmm.
The latest position, my lord, today I don't have, my lord. But give me 1 or 2 days time, my lord.
On the prayer of Mr. Anjay Katonia, learned counsel for the petitioner, raised it to list this matter again on Wednesday.
Yes, my lord.
The public will sleep on the
statement.
Yes.
Item 3 and 4.
Who is for the respondent? Yes.
Lordship has passed to the appears for the board.
Huh?
Speak for the appears for the board.
Call him. Time me. Mr. Kolda, get Mr. Chaudhary.
Item 5.
Find the affidavit, the order to direct him to find the affidavit, but they have not yet found it.
Okay, let him come. We'll see. Who is appearing for the respondent here? Litigation. And you are for the government.
Matters you are sent, disputed by the deputy commissioner, my lord, for the public interest.
How can you do that?
For public interest, you are sent to the.
What is the latest position?
Lordship, we have not received any instruction because the matter perhaps has been listed after 2022.
The man was posted on deputation without his consent. Then this court had passed a stay order.
In respect of one other petition. And has been next, the reputation to last.
London Borough, that is with regard to the petitioner itself. Where is that order?
Under not. Next of four page.
Annexure 4?
Page.
No. In the present case,
It is also state.
there is an interim order on 5/7/22, wherein the operation of the Umpun order dated 23/6/2022, insofar as the petitioner, London Borough is concerned, Brahma is concerned, is stayed.
For the public interest, you are sent, my lord. So this petition may be rejected.
Show me, how can you send somebody on deputation without his consent?
If, section would be required.
No instruction is required. 22 onwards, if you have not got instruction, what can we do? You can have a telephonic instruction at 2 p.m. where he is presently working.
Just 2 days time may be granted that lordship may take it up on Wednesday.
No.
Lordship,
We have enough matters on Wednesday.
because the matter as such has. not
You
been-
just call up the deputy commissioner, whether London Borough is working in his establishment or in the irrigation department. That much only you get now. He is an employee of yours, Ms. Fukan. Huh? Agreed? No dispute on that? Finished. Then we'll pass orders.
My lord, there is much in this.
Shall we pass orders? Mr. Bora, we'll pass orders. Or you want an instruction to be taken?
Just let me get some.
Two upon.
Item 6.
Item 6 of it, I have received the report from it. Can you please again? It's a vacation, Malak. I have to go through the Malak report.
Yes, madam. What is your case?
Yes. On the death of Gojendra Pathak filed his wife, Priyama Pathak is filed this case.
We know that.
Already.
Why is this order dated 2/3/2019 ban?
Yes.
What is the error in that order?
Order dated
2/3/19, that is under challenge, page 91.
2/3/19, yes. First, last inquiry, yes, my lord. Matter is that 24/9/14,
What is your ground?
he is removed from his service, Your Honor, and petitioner filed WBC first time 537/4/2014 before the Honorable Court to challenge this removal order, Your Honor. That Honorable High Court on dated 12/5/16 set aside this removal order and direct the within 4 weeks direct the petitioner
I got it, ma'am.
consider two representation.
This is the order of
Yes,
this
yes,
court.
yes.
Then what happens?
After this, respondent authority directed Honorable Court to within 4 weeks another re-inquiry. Engage to another inquiry officer and re-inquire the matter. But on the entire date, respondent authority appoint another re-inquiry officer, but uphold that without re-inquiry the matter, uphold the earlier inquiry report. And petitioner, this inquiry report is not served upon the
Where
petitioner.
is
Your
your
Honor.
statement to that effect?
According this last
Madam, where is your
inquiry-
statement to that effect?
the last inquiry report, according this petitioner is removed from his.
I got it, madam.
2019,
Where is your statements to that effect? That there was a re-inquiry, you were not made a part. Where is those statements? Okay, got it. Have you filed an affidavit here, Mr.?
Affidavit, well, that
Now,
record was
now if you come to page 91, what is this you are doing?
91.
91? This court's direction is very specific,
Lot.
that he had given two representations
Right.
against that inquiry report. Consider that and pass orders.
That's
Now, where is the power of a appointment of a re-inquiry officer? De novo inquiry. And that too without bringing the petitioner into the fold?
That's why the record was called for. Record was called for.
Hmm.
On the record, that I. I'm sorry, Lord.
The man is no longer there. His family is waiting.
Lordship.
So how far we will delay? You go through the record, we'll take it up tomorrow. Madam, tomorrow?
Can it be a lordship on Thursday, Lord?
Thursday, there are a lot of matters fixed, huh? Who doesn't know?
18, or not, I have a lot of matters in court.
Many times, many days
The
is
idea-
over, Your Honor. For record.
You don't want it. As prayed for by the Learned Council for Mr. J. Handick Learned, Standing Council, Revenue submits that the records of the matter has been received by him. However, he is not in a position to peruse this thing. Accordingly, he submits that he be given 2 weeks' time to peruse the records of the matter. First, a prayer accepted. First, prayer is not objected to by the Learned Council for the petitioner. Accordingly, registry to list this matter again after 2 weeks on a date to be fixed by 2 weeks.
Obliged, Your Honor.
Obviously.
Malaga, she really good job. Very good.
Item 7.
Madam, what is left in this matter? The report has already been placed before the legislature. So,
Lordship, be at 2 PM, senior says on live.
timing.
Item 8.
But the.
My lord, here, my lord, I need to file my affidavit. I'm sitting in accommodation of 3 weeks, my lord.
Right?
Perhaps, my lord, some miscommunication, my lord, I appear for all the respondents. Petitioner is working as a driver, although under this election process, he is getting a fixed pay, but is claiming a regular scale of pay as well as regularization of his service.
Regularization, forget it. That is not that he is not going to get. But
Let me-
what about the minimum? At least the minimum.
At least-
Upendas would come in.
Absolutely, but
Then?
if I may file my affidavit, my lord.
That nobody prevented you from 2023.
Absolutely. My lord, I have gone for the file, my lord.
See, these small issues, the matter is pending.
Absolutely correct, my lord. But I do not find, my lord, any proper communication. I undertake, my lord, I will inevitably file an affidavit.
But
Lordship will kindly accommodate me for
Mr.
3
Sharma
weeks,
will
my
give him a last sentence. R. Sharma, Learned Counsel for the petitioner, also heard Mr. R. Bafujari, Learned Standing Counsel, Learned Counsel appearing for all the respondents. Mr. Bafujari submits that he would invariably file the affidavit on behalf of the respondents on or before. On or before.
My lord, can it be, my lord? 17th of July, my lord.
So on or before 17/7/2025. Full stop. It is provided that no further time would be granted to the respondents to file their affidavit. Full stop. In the event such affidavit is not filed on or before 17/7/2025, comma, on the next date of listing, this court would proceed to consider the issue arising in the present proceedings, basing on the materials already available on record. Registry to list this matter again on 23/7/2025.
I'm so obliged.
Item 9.
Pass over for time being, Lordship.
Also, we are supposed to file an affidavit, madam.
Forget your
Some,
affidavit.
Sometime in.
Forget your affidavit. 23 onwards, you have not filed, don't file.
But,
Now, tell me one thing. Why was their case not considered?
after this representation which they have given,
What is can you go beyond the act, Mr. Fugan? Can you go beyond the act? Act says 2016-17. Why are you considering 22? You cannot. Get your instructions. We'll have it tomorrow. Day after. Goodbye. Bye, sleep very good. Yep, just that much. Your act says 2016-17. Enrollment. If they have that, you cannot deny them an opportunity. Just check and verify that. Wednesday.
Item 10.
Have you seen the affidavit?
My lord, no evidence. has
No,
been
no.
yet.
Have you seen the order? Order passed. Huh? Where is that order, impugn order?
Impugn order, my lord, it is 151, my lord.
140.
151.
Nobody is appearing for the BTC.
Yes, my lord.
It is not BTC.
BTC, yes, my lord.
Mr. P.
BTC
Chaudhary
as
is
well
there.
as, state government.
Can be taken up sometime.
Have you gone through this order?
My lord.
Have you gone through page 151, 152?
Yes,
That
my
is the impugned order.
Yes, my lord.
What is your take on this?
My lord, kindly, my lord, 152, my lord, the findings, my lord. In view of the evidence, the claim of the petitioners cannot.
Now, where is this policy? There may have been some policy, but they say that both BAC as well as BTC have not taken any policy decision. And naturally so. There was no such concept in the state of paying a stipend to the people working in venture college. Grant in aid was generally given. Grants in aid will not come. But where is this concept? And when was it stopped in your case?
My lord, 1997, my lord.
97.
Yes, my lord.
When did you approach
Since then-
this court?
Since then, my lord, we are approaching before this court.
No, no. You approached this
Earlier-
court, my Lord Justice Silo's order.
No, my lord, earlier also, my lord, 2003, my lord, we have approached 2003, my lord.
Have your schools been provincialized in the meantime?
In the meantime, already got.
Provincialized?
Yes.
That's the end of the matter.
Since the appointment order itself, my lord, stated that till provincialization, my lord, granting stipend, my lord, will continue, my lord. But without, my lord,
When were you provincialized?
my lord, in the year 2017, my lord.
Under the 17 Act?
Yes, my lord. So our grievance, my lord,
Then we'll have to give this to all. How can we single it out to you?
my lord, another similar rectification is, my lord, pending, my lord.
You come to para 4, page 152. Read.
Para 4, my lord. That the petitioner has stated the service of some petitioners have already been provincialized. As
No, no, no. Para 4, 152.
all this.
Page 150.
Yes. Director of Education, Borderland Territorial Council, Kokrasar had informed by letter dated so-and-so, that granting 8 teachers are engaged at various Ansar AP schools in the year 1995-96 by the then Deputy Inspector of Schools, Nalbari, Kokrasar, for so-and-so against non-existence and non-sanctioned post as per policy decision taken by the Withdrawal BSc. The school have received granting aid for few months and discontinued. The said engagement of teachers as granting aid was made with the condition that the erstwhile PC would not bear any financial responsibility and order of granting aid be cancelled at any time without giving any notice and without showing any reason thereof. In this connection, As reported, the PTC authority has not taken policy decision for granting statutory granting aid to those venture schools. The present BTC government has not taken any policy on the scheme initiated previously by the then erstwhile BTC, BSc in 1995.
So we cannot, your appointment letter itself says that this is without any liability to the BSc. Now if there is no money, no policy sanctioning stipend to the teachers in the venture school, how can we bind them now? Think over it, gets Mr. Chaudhary, we'll take it up after some time.
My lord, can it be on day after tomorrow?
Same thing,
My lord,
same
day
thing,
after-
same thing,
kindly, my
same
lord.
thing. I've read it, same thing. You
And
get
another-
Mr. You get Mr. Chaudhary.
My lord, in this case, my lord, your lordship was also, my lord, there. So that is,
Where? I was there
yes, my lord.
for the Rabindra Basumatari.
My lord.
Where, which case?
No, my lord, my lord, the batch of petitioners on the file petition, including this petitioner also, my lord, that is, my lord,
Where is that order?
that order, my lord. My lord. That is, my lord, page 10, my lord, but your name, my lord, your lordship's name has not been reflected, my lord.
Then-
In fact, your lordships are there, my lord.
You want an adjournment? Take an adjournment. Don't make these submissions. As prayed for by the learned counsel for the parties, the registry to list this matter after the affidavits filed by the BSc BTC authorities in the matter.
Obliged, my lord.
Mr. Counsel, you want an adjournment? Don't want to do the matter? Just say I want the matter adjourned. Don't make all this
No, my lord, your
stories.
lordships
I
are
have
there.
never appeared for this. This much I know. I've appeared for certain matters with Madam. I know that. Madam Devi, please don't make such
Sorry, my
submissions.
lord.
Item 11.
I'm agreed by non-consideration of my application.
Where is that act?
What should, it's in this manual itself.
Hey, very fun actually. What's the page?
Page 8, it starts, page 8.
Page
8,
8.
8. And section, rule 10, lordship will find at page 16. These are the grounds, and since my mother is ailing, lordship, rule 10 will cover me, lord.
You are seeking a transfer inter-district or within the district?
Inter-district. lord.
Inter-district. So it will be rule 7. How long have you been working there?
Lordship, my appointment was of 27/3/2017.
2000?
2017, lordship.
So you have not completed 10 years.
Yes, lordship, but there is a communication whereby the mission director say that it's not mandatory.
When the act says who is the mission director to take a
Because,
contract?
there's a.
Rule 7A.
No, lordship, that is there, but the state selection committee under rule 5, mission director heads it, lordship. So he has given a clarification with regard to this law. At paragraph 3. My application was accepted and it was forwarded for consideration, but till now it has not been considered.
Where are you posted now?
Now I am posted as South Salmara Girls ME School.
And you want posting to?
Posim Panduri ME School.
Where is that?
It's a Romia lot.
Kamrup Rural.
Yes, Lord.
Yes, Mr. Talda.
My lord,
What is your instruction?
sanction yet to receive, my lord.
Why?
Because my lord is, there is, my lord,
23, this matter was moved.
up to date instruction, my lord, or notification, my lord.
On the first day of when the notices were issued, 10/5/2023, you were required to take instructions and place them before next date. Next date, 22/5, again, accommodation for instructions. Then 26/6, it was adjourned on behalf of the petition. Wait, small thing, if it is rejected, tell him it is rejected. If it is allowed, it is allowed.
That's why, my
It
lord,
is,
I
ball is
pray
in
for-
your court.
pray for 2-3 days time, my lord.
2-3 days time. Okay. Budba.
My lord.
On the prayer of Mr. B. Talukdar, Learned Standing Council, School Education Department, raised it to list this matter again on Budba, Humba, 23. On the next date of listing, the for completion of his instruction, full stop. It is directed, it is provided that no further adjournment in the matter would be granted for receiving instructions by the responsible authorities. You can keep this file.
Item 12.
Obliged.
Amen. Yes, who is appearing? Government, you are there. Why his case is not considered?
But today I have received instruction, but his post was considered for the second post matter.
Hmm.
That is why, my lord.
Now it has become a higher secondary school.
Yes.
Now, once it becomes a higher secondary school, I think there is a increase in the post strength of grade 4.
Now it's a higher secondary school.
Why keep this matter pending? Consider his case. When did it become a higher secondary school and where is the relevant provision? Mr. Muzumdar?
What if, it was last financial or page 34 lordship. Now amalgamated as higher secondary school lordship. Order is page 35, my school name is serial number 11 lordship.
You will be under that new act, that 2018.
Okay.
No, that, what is that? Non-teaching staff.
Yes, my lord.
Seven. So, grade 4-3 is permissible now.
But since the school has already been provincialized, my lord.
That
now-
is under the 2011 Act, that is gone.
That is why, my lord. Now, if it is, if we need to fill up the post, then.
You cannot,
Direct recruitment, my lord. If
you cannot. Mr. Counsel, you cannot. That 2011 Act, whatever has done, it's inconsequential.
exactly, my lord.
Then,
Because during that time, there was a second post, that is why his case was not recommended by the
that
committee. my lord.
2011 Act is the 2017-18 Act.
That was the, because of his second post, it was not
That we
recommended.
will not accept.
It's not recommended, my lord. So now,
They not recommended because there was no post at that point of time. Now
Yes.
the school status has changed. It has become a higher secondary
exactly, my
school.
lord. But
Then-
it's now it's a provincial school, my lord. Now this school is provincial higher secondary school, my lord. So now if we need to fill up any post, my lord, that has to be through a direct recruitment, my lord.
How? Have you done the exercise with regard to 24 with regard to this school?
24
Have you-
exercises,
Have
As
you
per
done
my-
the exercise of 24 that you have do under the 2017 Act with regard to the employees provincialized under the 2011 Act in this school?
as per my knowledge goes, my lord, that exercise has not been
Then,
undertaken.
then. That is not accepted, Mr. I'm sorry.
But my understanding is that since it is a provincial school,
We accept your understanding, but it cannot be deemed to be a provincialized school like the schools provincialized under the earlier acts, 77, 82 acts. This cannot be because 2011 Act has been set aside
yes,
and it is governed by 2017.
17 lakh.
Now, if it is 17, section 24 will kick in. And this 2018 Act with regard to non-teaching staff, that is again different. If you can come to that. So this is the first time an act is there for the non-teaching staff. Earlier 11, inconsequential. So this you will have to do.
But my lord, I should file an affidavit.
You need not file an affidavit. 20, how long this matter is pending?
It's a 23 matter.
Ah, you take a call. We'll direct you take a call. Anything else, Mr. Majumdar?
I leave.
Heard Mr. K. Majumdar, Learned Counsel for the petitioner. Also heard Mr. N.J. Katunia, Learned Standing Counsel, School Education Department, appearing for the respondents number 1, 2, 3.
Three, madam.
What is the name of the school now? It is not a madrasa now.
Jambari Higher Secondary School, my lord.
Jambari Higher Secondary School, Lordship. Page 35, Lordship, I have
Also-
given the type copy of the original letter, Lordship.
The petitioner in the present proceeding has raised a grievance with regard to the inaction on the part of the respondent authorities in not considering his case for provincialization of his services against a vacant post of grade 4 available in the school. Full stop. The petitioner was engaged by the managing committee of Jambari High Madrasa, Dhubri, on 5/2/2007 against as a grade 4 employee. Full stop. The said madrasa was provincialized. Where is that order?
Lordship. Just provincial.
Provincialized by order dated 38/2013.
13.
And along with the other staff working in the school eligible to be so provincialized, a grade 4 post, a grade 4 employee, Tomezuddin was also provincialized as against the grade 4 post available. Also, it is to be noted that the name of the school was thereafter changed as Jambari High School. Also, in terms of the provisions holding the field, only one under the Act of 2011 to indicate only one post of grade 4 employee was liable to be so provincialized in a high school. Also, it is projected in the, when was it converted to higher secondary?
Lordship, on 26/4/2022, Lordship.
26 for
2022.
20?
2, Lordship.
Also, it is contended
Page 34.
by in the writ petition that the said school was thereafter upgraded as a higher secondary school and renamed as Jambari Higher Secondary School. Full stop. It is to be noted that after the setting aside of the Act of 2011, comma, for the purpose of regularizing, provincialization of the non-teaching staff, the authorities had framed the Assam Education bracketed provincialization of services of non-teaching staff of venture educational institutions bracket over Act 2018. So, in terms of the said Act, comma, a higher secondary, in a higher secondary school, comma, up to 3 posts of grade 4 is permissible to be allotted and persons provincialized against the same. Also, in the case of the petition, the bar existing when the school was a high school of not of a bar existing with regard to provincialization of more than 1% against the grade 4 category when the school was existing as a high school, comma, having been removed with the upgradation of the said school as a higher secondary school with effect from 26/4/2022, comma, the petitioner's case is now required to be so considered, given its due consideration in terms of the provisions of the said Act of 2018. Full stop. I'm not recording your objections, but only I'm directing that it should be considered. Full stop. In view of the above position, comma, the Director of Secondary Education Assam is directed to consider the case of the petitioner for provincialization under the provisions of the said Act of 2018 and for the purpose, here also DLC is there.
Yes, madam.
And place the case of the petitioner before the jurisdictional district scrutiny committee for verification of the service particulars of the petitioner. Thereafter, basing on the recommendations made in respect of the petitioner by the jurisdictional district level committee, the Director of Secondary Education will have the case of the petitioner further considered strictly in terms of the provisions of the Act of 2018. Also, on conclusion of the process involved, in the event it is found that the petitioner is eligible to have his services provincialized against the grade 4 post available in the school in question, comma, the Director of Secondary Education shall issue appropriate orders provincializing the services of the petitioner and extending to him the benefits as extendable under the provisions of the Act of 2018. The said exercise shall be initiated and concluded within a period of 3 months from the date of the receipt of a certified copy of this order. The petitioner shall furnish a certified copy of this order to before the Director of Secondary Education along with a representation and the representation disclosing his service particulars, comma, qualifications, etc. Full stop. With the above observations and action, the petition stands disposed.
Much obliged.
Obliged.
Item 13.
Kindly pass out for the delivery. My senior is not able to. Any date of this week.
Mr. Khatonia, what is this? This is. Oh, this is revised. Okay. This list at page 53. This is in pursuance to some selection process. Mr. Mullah, you are appearing for? When was your school provincialized? Don't know. Are you in the matter?
No.
On behalf of an
19. He was 1992. He was appointed in 99.
Yes,
How can a managing committee appoint somebody after the school is provincialized? Where is Mr. Dr. N. Ahmed, M. Zaman, A. Bosumatari, D. Hussain? Get somebody. Others I'll dismiss it for default. If you don't want to do the matter today last, kindly put in an application. I'll not read it. But if there is no application and the reason is not urgent coming up in the morning, I'm not adjourning matters. And these matters need not be adjourned. Okay? You come up, ask anybody who is there in the case to come and argue. They are next to me.
Item 14.
Raised to list this matter after disposal of writ appeal number 287 of the 2023 preferred against the judgment and order dated judgment and order of a coordinate bench dated 31/2023 in WPC number 1646/2023. That 3 years residual.
Yes, my lord. It was supposed to be listed in the first week of June.
Let it come.
DB.
Mr.
Somehow it got-
Madhavia, that matter is pending in the division bench. Let it be over, then we will consider.
All right.
Item 15.
Wait, please, Aman. No, no, the matter will be passed over for the title. But senior within Lexi Namagai.
Who?
But senior is Lexi Namagai.
Have you read the brief?
No.
Why?
File is with my senior lawsuit.
He does not give the file to you.
Right.
What is this, Mr. Bora?
Your lordship,
The BSc is not a recognized board. But my hands are tight because they have now brought a fresh selection process and they have not implemented. Have you implemented who is your senior?
This way, yes.
Get it. Today I was shocked to know that even the government of Assam does not, social welfare department does not recognize CBSE.
Yes.
CBSE is an unrecognized board.
Item 16.
We'll see.
Regarding
Who is appearing for the government, India?
Lordship, I am appearing.
Yes, what is this?
Lordship, I have received the instruction. I pay for some time.
You have been given enough time. See, you have admitted that her father is a Swatantra Sainik.
Lordship,
She was getting pension.
Lordship.
Her mother was getting pension.
Right.
You have even admitted that she is an unmarried dependent girl.
Lordship.
Huh? And you don't give it to from 2005, you're giving it from 2019. And now I propose to give it along with interest.
Let me have the insight because
This is something, Mr. Roy, why we are, because of people like the father of the petitioner, why we are now
Lordship, that's.
holding this court without any fear or favor. You get my point?
I understand.
And they should not be put to trouble. I want the payments to be made. When? You give me, you take your time. And this is due to her. And the state of Assam has categorically said that it is from the date 2005 that she is entitled. Right?
Yes.
When? You give me a date, you take your time, take the matter with the authorities.
Lordship, that's right, Lordship.
You give it, I'll not pass an order of interest. Otherwise, I'm going to cost heavy interest on you. Because that girl was left in a destitute position for long. We cannot ignore that.
Lordship on 25th July.
July, okay. Mr. S.S. Roy, learned counsel for the petitioner, for the respondent submits that the respondents represented by him are reconsidering the matter, would reconsider the matter and would come out and take a fresh decision thereon with regard to the entitlement of the petitioner for receiving the pension involved with effect from 2005. What is the date?
3/12/2005.
3/12/2005. So accordingly, he submits that the matter be adjourned and taken up on
5th of July, Lord.
25/7/2025, by which date he shall apprise this court about the developments taking place in the matter. So prayer accepted, registry to list this matter again on 25/7/2025.
Obliged.
Mr. Roy,
Lordship, I
take it up very seriously.
Item 17,
This petition has been
Liability.
passed up. Already, my lord, that new
matter
act,
has
well, I
been
already knew
passed.
when.
So you don't have a case.
Lordship, the matter has become the infectious as the Act of 1935, Lordship.
1935 Act is not there. Unfortunately, that act has been repealed. We have a new act repealed on
But it is appeal on my lord.
23rd February 2020.
the, your name?
Appeal on my lord that 16 feet, my lord, that garage notification was published on 16/3/2024.
So the issue raised in the present proceedings emanates from the provisions of the, what was that earlier act called?
Earlier, my lord, the Muslim marriage, the Assam Muslim Marriage
19.
and Divorce Registration Act 1934.
Just write it down for him.
Lordship.
He will write it down for you. Thank you. So it is stated at the bar that the said act was repealed
White Gazette notification dated from 16/3/2024.
by the Assam repealing ordinance 2024. Assam Muslim Marriages and Divorce Registration Act 1935, Agewala. And that was repealed by the Assam repealing ordinance 2024. So it is further submitted that that new act, what is that called? Has been now replaced by the, just give a gap, he will give you the name. Just give a gap. So in that view of the matter, the grievance of the petition, in the above view of the matter, the grievance of the petitioner being based on the provisions of the Assam Muslim Marriages and Divorce Registration Act 1935 and the same having been repealed, the present petition cannot be, they would not be further required to be given as consideration. So, however, liberty is granted to the petitioner to file appropriate application if any further grievance exists in the matter. So, with the above observations, the present petition stands closed. Just give the.
I will. Marriages and Divorce
can
Act
keep those.
24.
item 18,
Obliged. The other side is after vacation.
You don't want to do it. Second round, Mari.
item 20,
Sorry, ma'am, I'm not hearing you.
Is the matter after 1 week
No, reject.
as we can take the steps.
Huh?
As we can take the steps.
No need, no need to spend more money. We'll close the matter today itself. You make your submissions. You are there in the matter?
Thank you.
Timely. Ask Mr. Chetri to be here.
21.
I got instruction from the petitioner. The petitioner do not want to raise this matter.
Rightly so. Miss
Emroy.
Huh?
Emroy,
M. Roy.
yes.
M. Roy, Learned Counsel for the petition, submits on instruction that the petitioner desires not to press the matter any further. So, accordingly, she prays that she be permitted to withdraw the present writ petition. Prayer is not objected to by the Learned Counsel for the respondents. So, in view of the above, the present writ petition stands dismissed on withdrawal.
Apply.
Item 22.
Musahari was supposed to, Madam Musahari was supposed to receive some, you have it? Where are the Supreme Court judgments? Yes, yes, page 51. 51. Yes, Mr. Khatoniar, what do you have to say on this?
Yes, sir.
These similar persons were appointed under 2011 Act.
But you can't get it 2011 now. You will get at best 2017 consideration. Mr. Khatoniar,
Yes, sir.
we are not rushing down. There are few matters more like this. You take a call.
The only difficulty is, madam, in the 2017 Act, there is a cap, madam, regarding number of students. But in 11 Act, it was not.
There was
there.
no cap.
Yes, madam. And in
And
common
this
study,
consideration is with regard to 2011 Act only. Yes, Mr. Sinha.
So, Lordship, these are all similar persons, Lordship.
I'm sorry that act, a single factor addition or subtraction in a fact can change a decision's ratio. It can make it inapplicable. Now, in the 2011 Act, subject to correction, there was no cap on the number of students. Here you have a cap. Cap that this much students is required plus the pass percentage. That 30% has to appear. Yours is a high school.
High school.
30% has to appear in the highest exam, matriculation. Now, this was put to challenge, and in all probability, the division bench had not interfered with these provisions.
Lordship, otherwise, Lordship, these petitioners are eligible as same as that, Lordship. That
I got it,
petitioners.
but the thing is that now the situation has changed. Even those petitioners subject to correction may not be now eligible because in terms of the orders passed by the division bench, setting aside 2011 Act and the review order, their cases have to be considered under the new Act, which is the 2017.
But these similar persons is considered under 2011 Act, Lordship, as they are
That
giving effect for
consideration we
2016.
cannot give now because that is again barred by the division bench. 2011, what has happened has happened.
But Lordship, kindly see this order at page 5. These are giving effect from 2016. At that time, Lordship.
No, that
means-
is in terms of the Supreme Court order. Page
Page 5, Lordship.
5.
Lordship. These are given effect from 1st of June 2016. Oh, sorry. 57, Lordship.
Hmm. No, this is in compliance of the Supreme Court order. You were not before the court at that point of time.
Lordship,
I
I-
can't give you this order. This can only be given in terms of the directions which went up to the Supreme Court. And the Supreme Court orders are limited to those petitions who are the appellants. As such, we direct the state to implement the order dated 25/5/2016 passed by the learned single judge of the High Court, who are the appellants herein within a period of 4 weeks. So how can we go beyond that? How can we extend it to you? Mr. Sinha, I'm not putting you into trouble. You examine the matter further. Come back after vacations fresh, we'll consider. Mr. Khatonia, let him.
Yes, yes, ma'am.
On the prayer of Mr. S.K. Singh, learned counsel for the petitioner, registry to list this matter immediately after the opening, immediately on opening of the courts after the ensuing summer vacation.
Obliged.
23.
Yes, Mr. Dhar. Why this is not being released? Have you disputed the amount? Then,
This is not about my we are not disputing. First thing is that when I don't get an extra copy, I don't send it. But I have spoken to my MD yesterday.
this is a colleague. You should not. He is assisting this court.
I'm trying to assist it to my lord. Yesterday, I was already spoken to the managing director. His version is that, my lord, we do not have any contact with him. If you want to pay also, we don't have his number.
Ask your director, managing director, to get a check. We are fixing it on Wednesday. Check in the name of the Registrar General. We'll disburse the amount to the petitioner. Mr. Adhar submits. Okay. That check you bring it on Wednesday in the name of the Registrar General of this court. We'll disburse the amount to the petitioner. If that is the thing.
No. My lord, I do just, he's my colleague, so I don't want to bring in lot of issues.
We don't want. Whatever he is entitled to him, release it. Tell me how long will you take?
My lord will dispose of this matter.
I'll not dispose of it.
Well, I'm giving my second.
I'm not disposing of. I don't want an advocate of this court to come up with a contempt petition. I don't want.
It will never happen.
He is an advocate of this court. I don't want him to. We will see to that he gets the money. You tell me when. Before vacations, nothing like it. Because your only objection, it seems from your director, is not in touch. Get a check in the name, draft in the name of the Registrar General. We will distribute it to the petitioner.
My lord will fix the matter. On 26th.
Mr. Ad hoc learned counsel for the respondents submits that the claim of the petitioner is being actively processed by the authorities, and he submits that the matter be taken up again by this court on 26/6/2025, on which date he shall apprise this court about the developments taking place. So accordingly, registry to list this matter again on 26/6/2025. That should be the spirit.
My lord may make an observation that I may be allowed to get a check in the name of research.
Also, at this stage, it is to be noted that one of the objections as intimated to Mr. Radhor by the director of
Assam Government Marketing Corporation Limited.
Of the Assam Government Marketing Corporation Limited for non-release of the dues to the petitioner is that the petitioner's contact details are not available with the corporation, and further, his bank account details are also not known. It is also highlighted that the petitioner is not in touch with the authorities of the respondent number 1 corporation. If that be the issue, the managing director of the respondent number 1 corporation shall compute the dues receivable by the petitioner and would take out a bank draft of the amount involved in the name of the Registrar General, Guwahati High Court, and hand over the same to Mr. R. Dhor for placing the same before this court on the next date of listing. Done? Let the council get something before the
No,
vacation.
my,
Mr. Dhar is there, I'm confident
there,
something will happen.
there is no dispute, my lord.
Then
24.
It's. Of the petitioner.
what happened to the inquiry?
Or they,
Inquiry is completed.
I know that inquiry is completed,
Yeah,
inquiry
this is
report
certificate, but
submitted. Because of the OM that it should be, have the signature of the chief. What happened after that? This was submitted in 2024.
Second suppose notice or reply has also submitted by the petitioner.
You have given him a second show
Second
cause.
suppose,
So when are you taking a decision?
in 3 weeks.
Huh?
3 weeks.
Why? Why?
So many cases are pending, Lordship, as per my knowledge.
I'm only concerned with this
Lordship,
case.
Lordship.
And you are also concerned with this case. You
Lordship.
can't have a general application.
So 3 weeks, Lordship.
No,
2 weeks, Lordship. Then 2 weeks.
before vacation.
Before.
So if something adverse goes in, he has the vacation to take steps. When? Let us. It is submitted by the Learned Council for the, you are for
Revenue
the,
Department.
huh?
Revenue
For
Department.
the Revenue Department that the inquiry report has been furnished to the petitioner and he has also submitted his representation against the same. Full stop. It is further submitted that the disciplinary authority of the petitioner is presently considering the material brought on record in the inquiry report, in the inquiry, as well as, the inquiry report and the representation submitted against the same by the petitioner for the purpose of determining determining as to whether a penalty is called upon to be imposed upon the petitioner, and if so, the quantum of such penalty. Full stop. He submits that the disciplinary authority would pass the appropriate orders on or before. We'll have it on 16
16th of July.
July,
Lordship.
on or before 14/7/2025. They take some time, so let's raise on or before 14/7/2025. Raised it to list this matter again on 18/7/2025.
Okay.
I am for as per 2 and 4 months.
Mr. T.C. Chutia, बोल में लिख देना. T.C. Chutia, learned additional senior government advocate, is present for the respondents number
2 and 4.
2 and 4. Don't put it in, put it in normal.
25.
This case your lordship is over with the
But there is a appeal. What happened to the appeal?
appeal, your lordship has your lordship dismissed the appeal.
Oh. It will not be a res judicata, I suppose. Oh, that case, Mr.
Lord.
Majumdar had appeared.
Lord.
Your lordship.
Yes, Mr. Chutia, nothing is left here.
We have not received any instruction.
You did not. We have the instructions from the division bench.
But I have
That
not-
decision which they are seeking, similar order, was taken up on appeal by you. That has been dismissed. So my Lord Justice made his order, is upheld.
That will.
So we'll apply that similar order here. Disposed of, what did it do?
Deeply approved.
Item 28.
Yes. Mr. Chakravarti, you are appearing for the AG. Why this 6-year deduction?
Yeah. PT department has an input common office.
Forget it. Forget it.
So the order earlier was
to the petitioners. That's why now the difficulty for us.
Sangeeta Roy.
Otherwise, it will be covered.
That is covered. Okay. None appears for the petition on call. So, Mr. B. Chakraborty and Mr. B. Chakraborty, Learned.
Respondent number 6.
No, if to N. Upadhyay, Learned Standing Council, Irrigation Department, it
1,
appears
4 and 5.
1,
4 and 5.
4, and 5. Mr. B. Chakraborty, Learned Standing Council, Accountant General, bracketed Assam, bracketed A and E, A, Roman and E, comma, Assam, appears for the respondent number 6. Also, the grievance raised, the petitioner by way of instituting the present proceeding has raised a grievance with regard to the deduction of 6 years from the gross qualifying service of the petitioners. And thereafter, gross qualifying service of the petitioner. Also, she has further prayed that the pension and pensionary benefits releasable due to her husband, to her deceased husband, Umesh Chandra Das.
I didn't know with 39.
28. Huh?
Junior of seat representing the.
Now, what do you want?
Yeah, he's spoken about Songita Roy.
Huh?
Spoken about Songita Roy. I thought that it's lab with 39.
Item number
39.
39 is not club. We'll take it up.
Lordship, he wants that name should be recorded there.
Huh?
Lordship recorded, none appears, their name should be.
I did not get you.
Actually, I thought that when it's spoken about 30, Songita Roy. So
No. Sangeeta Roy 39. That is a contempt matter. The order has not been complied.
Yes.
That we will take it up separately. Good. Umesh Chandra Das has to be calculated by taking his service with effect from 1/1/75 till 31/12/2016 without any deduction. Also, the said issue. Also, the deduction of 6 years was being so made from the pension and pensionary benefits of the regularized muster roll oblique work charge employees. In terms of a policy decision of the government. Of a policy decision of the government as contained in the office memorandum dated 25/2009. Also, the said office memorandum dated 25/2009 required that the qualifying service of a muster roll worker, regularized muster roll worker, shall be so determined after deducting 6 years from the muster roll services rendered by such muster roll oblique work charge services rendered by such a regularized muster roll oblique work charge employee. Also, the said issue was considered by a coordinate bench of this court in the case of Sangeeta Roy. Sangeeta Roy and Sangeeta Roy versus State of Assam. Sanjita, S-A-N-J-I-T-A, Sangeeta Roy versus State of Assam and others. And the same was disposed of by order dated, a judgment and order dated 4/12/2028 in WPC number 1089/2015. Also, the operative portion of the said decision judgment being relevant is extracted here in below. Para 29, 30, 31, 29, 30, 31. You will get it at page 56 and 57. Also, applying the said decision to the facts of the present case, it is seen that the petitioner hearing is also similarly situated like the petition in the case of Sanjita Roy. Also, supra. Accordingly, the present petitioner is also entitled to the benefits as extended by the coordinate bench of this court, widely said judgment and order dated 4/2018. Also, the pension payment order of the petition brought on record reveals that the petitioner had a gross service of 42 years, 0 month, 0 M, 0 D. And therefrom, a period of 6 years, 0 M, 0 D was deducted. And his net qualifying service was determined as 36 years. Also, basing on the net qualifying service, so determined the pension and pensionary benefits of the petitioner was so fixed. Also, accordingly, the Accountant General A&E Assam shall now redo the recompute the qualifying service of the petitioner after adding the 6 years deducted earlier from his gross service and thereafter issue fresh pension payment orders to the petitioner, to the in respect of the husband of the petitioner. Also, the areas of pension due to the husband of the deceased husband of the petitioner on account of the recomputation now required to be made in terms of the directions passed herein above shall be released to the petitioner hearing. Also, the areas of family pension becoming due to the petitioner on account of the recomputation of the pension and pensionary benefits of the of our deceased husband shall also be released to the petitioner. Also, the areas now becoming due in terms of the directions passed by this court herein above shall be released to the petitioner within a period of 3 months from the date of receipt of the copy, and within the set period, the fresh PPO/GPO shall also be issued to the PPO, FPO, the PPO and the PPO only the family PPO would be issued within the set time frame. With the above observations and directions, the present writ petition stands disposed of. Ivan Asiledu.
Item 30.
28. My lord, this is my lord including petition lordship.
Where is the petitioner? You are the petitioner.
And the petitioner, let's see.
You are for the respondent.
My lord, for a pleading application.
You come decide.
Yes, lord.
May I please, your lordship, later pardon the family pension. Here, lordship,
My lord, so far,
in this case, lordship, already the pension paper ready by the district authority. And district authority hand over the documents to the, in the hands of the petitioner. Instead of submitting in the office, higher authority. Lordship, all the documents, which are prepared in the 2 sets, all are in my hand.
Why? Why have you not submitted it before the?
I personally, along with the petitioner, went to the office, but they did not receive such copy.
Which office?
Uh,
Who gave you this document?
Chief engineer,
Who gave you this document?
documents given by the district authority, lordship, executive engineer.
Executive.
well, why, my lord, this application is submitted lordship? We kindly see the prayer lordship. Well, as regards, my lord, pension, my lord, family, we have no objection, my lord. As regards other, my lord, service benefits, my lord, gratuity, leave encroachment, my lord,
etc. My lord, these are my lord different things, lordship. On my lord, on that, my lord, prayer, my lord, we have to say no. Now, that is why you have filed my lord, a pleading petition.
Yes, Mr. Upadhyay, what is the steps you are taking?
Lordship,
Why your executive engineer does not have a man to depute with for sending the papers?
Lordship, she should not have accepted, Lord. The petitioner should not. should
What
have
the
accepted.
petitioner knows? She wants her money.
Correct, Lord.
Huh?
Lordship, he can hand over it to me,
No, he'll not hand over it to you. You give it back to the district officer. Okay?
let them come.
Huh?
Let them men come.
My lord, the district authority already offered a petitioner and they have not received such copies.
Then you do one thing, frame it and keep it in your house. That is better.
But if the direction may be given that time.
You are not authorized to receive this.
Yes.
You give it back, let the matter go formally. They will send somebody to the chief engineer's office. We will proceed. Their claim, we will dispose. We are impleading you. We are impleading them. I'm fixing the matter because I have implead, I'll not pass the order today. I'm fixing the matter on Monday. On Monday, I'll direct the irrigation department to process the papers finally, submit it before the irrigation, before the authority in the accountant general. They being the children and the father of the deceased applicants, they will be entitled to the pension, other pensionary benefits, not pension, but other pensionary benefits. That will be determined by the chief engineer or the secretary, whoever it is. Then the proportionately, it will be shared between you, the second wife, son, earlier wife's two sons, and the father. Father is still alive?
Yes, father and son.
Father and sons, no? Grandfather and sons. Ah. Okay? And in the meantime, ask your petitioner to get this back to them with a receipt. Next day, you have to show me that receipt. I bracketed C 1526-2020. Heard Mr. M.H. Ahmed, Learning Council for Deputation. Your name?
M. Bora.
M?
M. Bora.
M. Bora. Also heard Mr. M. Bora, Learned Counsel, appearing for the opposite party number 1. Oblique writ petition. The present application, interlocutory application has been instituted by the sons and the son and the father of the deceased husband of the respondent number 1 and have staked a claim. Excellent superlative. The writ petition was instituted by the petition praying for a direction upon the respondent authorities for being authorized the pension and pensionary benefits in respect of the services rendered by her husband, Mothura, Mothura, Motak, Motak. Also, the present interlocutory application has been instituted by the 2 sons of late Mothura Motak and the father and his father. Also, the applicants claim that they are entitled to a share in the other pensionary benefits receivable. Other pensionary benefits that would now be required to be released by the respondent authorities on account of the services rendered by deceased Mothura Motak. The applicants in the petition, in the interlocutory application has undertaken that they will not be claiming the pension, family pension that would now be required to be authorized to the opposite party number 1 petitioner. Also, and they would be limiting their claim to gratuity, leave encashment, GPF, etc. Also, In view of the above position, this court is of the considered view that the applicants are necessary party in the proceedings of WTC number 1700 of the 2025, and accordingly, the present applicants are included as respondents number
9, 10, and 11.
9, 10, and 11. Also, the learned counsel for the petition shall file an amended cause title incorporating the names of the newly impleted respondents number 9, 10, and 11. Also, Mr. Emmett, also, with the above direction, the present interlocutory application stands disposed of. Also, of main petition. Also, in view of the order passed today in I bracketed C number 1526/2025, including up यहाँ से मान A2. Jayanta Das, Jayanti Das, Tileshwar Das.
One is Jayanta, another is
Joint.
Who is Jayanti?
One is Jayanti, I have two brothers also.
Hmm?
One is Jayanta, another is Jayanti.
Brother?
Yeah.
They are brothers?
Yes.
But wife of late Ratul Das, who is this Ratul Das?
I don't know.
Yes, who is this Ratul Das? But you said applicants number 1 and 2 are his children.
Jointo is the son, Jointi is the
Daughter.
daughter.
Son and daughter, 2 sons लिखा था ना? वहाँ पे son and daughter of Mathura. Full stop. A to A, including the following persons as respondents number. Respondents number 9,
9, 10.
9, 10, and 11. Full stop. Petitioner to file an amended cause title within 2 working days from today. Full stop. Raised it to list this matter. Raised it to list the petition. Raised it to list this matter on 24/6/2025 for further orders. You submit that in the meantime, get a slip. Yes, Mr. Chaudhary, what are you waiting for? 40? Opposite party is here. Okay. 44. Have you seen, senior is there? Relax. Yes, Mr. Chaudhary.
Yes, your lordship, kindly see the order dated, my lord, page 40 to 52, my lord. Page 52.
It took 50?
52, my lord. Order dated 13/3/19. My lord, whether amended rules or the unamended rules are applicable, that the question page 53, your lordship will find last portion, my lord.
Okay, fine. Mr. Chaudhary, you are work charge and
Regular class. I'm not entitled to get promotion, my lord.
no. You were initially what? A work charge
Initially, Mastagul and
Master-
Khalasi.
Khalasi. And then you were regularized in 2005.
Fine.
And then
Then I'm continuing.
continue.
Then the rule was amended.
Graduation was brought.
Graduation, we are all.
So issue was whether you will be governed by the earlier
Idea
rules.
rule. So court in court, then they say the government,
No, how many petitioners are there?
only one already retired, my lord.
So he is out.
Now 3 persons, my lord, your lordship.
Two.
And one person, your lordship will find page 4.
Hmm.
3 person, number 1 is going to retire next January, my lord, this January.
Prasad Kumar Roy.
Prasad Kumar Roy.
Okay.
Others
Sanjeev-
also, my lord, 127, 29.
Oh, they are still in service.
Still in service.
Okay.
Now you will kindly say page 54.
And all of them are graduates?
Yes, all are guilty. With diploma also, my lord, 1 year, 2.
Okay.
Now, page 54, they say that they are eligible, this school will be applicable, and the appointment will be made by the, your page 54. It is there order in terms of the honorable justice protection order, my lord. page 54, bottom.
Hmm.
The High Court, the concern.
Then you filed a contempt.
Yeah, then contempt was also there, they said vacancy is not there. Subsequently, the court said that whenever vacancy come, contempt was closed.
This was filed by, contempt was filed by some Moinuddin Chaudhary.
No, you're one of the petitioners now. One of the petitioners.
Petition number 3.
Yes.
Okay.
Other also there, madam, linked cases there, madam.
Okay, where is that?
Yes. linked case-
Rojalal Singha,
Yes,
Prasad Kumar Roy, okay, P1.
yes, all are there.
And Sanjeev Kumar Roy,
Yes.
P2.
Now, page 58, your loss kindness, madam.
Okay.
Paragraph 5.
Hmm.
Non-evident vacancies, so whenever vacancy comes, the case will be considered. That was the submission
Okay.
made on, your lordship order is dated 1/4/22, madam.
Okay, done. Got it.
Now we have submitted, madam, vacancy is page 68.
Hmm.
Vacancies are there, madam.
Hmm. Okay,
We have not denied it, madam. the vacancy.
okay.
This is our case, madam.
Mr. Chaudhary, there is a decision of the division bench
Right.
in Dilip Kumar Talukar, wherein that unfortunately for you is still holding the thing. Wherein it is said that where is your regularization order?
Yes. Your lordship will find. Paragraph, madam, your lordship will find petition one.
No, is the order on record?
Yes. Petition number at 150 serial number, my lord, your lordship. Serial number is,
No, your regularization order.
list is there, my lord. Seniority list of classes, my lord. Page 46.
Where is your statement with regard to regularization?
Yes, your lordship will find.
Okay. 2005, all are in 2000.
Yes. Their initial appointment at 87, 92, and brought a regular policy with effect from 22/7/25. Your lordship,
So-
paragraph.
So that decision says that once you have been brought from a regularized thing, then you are regularized against a personal post.
No, here they have not
Show
mentioned.
me. Show me.
No, they have not mentioned it is against personal. post.
They have not done it, but we cannot ignore it,
But
Mr.
they-
Chaudhary.
They have already, my lord, they have stated their our case will be considered, my lord.
But it cannot be because the law has been laid down in that manner. I cannot pass an order ignoring that division bench judgment.
So they have never, my lord, brought on the record that it is personal.
Mr. Borthakur is very eager to bring that on record, right?
There's no regularization order in the petition, madam.
Forget it, but they were regularized against personal posts.
No, that is not there, my lord.
Where? Show me that. That is
But-
what I want.
That, my lord, since discharge, that is only, my lord, we are having that order.
Mr.
Seniority.
You
list
can
of-
ask your junior
Yeah,
to get that. We will have it in the second half. If that is not there, you are not regularized as a
so
work,
if,
against as a,
yes, if it is not there against personal force, then I am entitled to it.
then you are clearly entitled.
Yes. Then, my lord.
You get that instruction, you also get a call. 2 will have it. Yes, sir. Just take your case out of that. We'll come back at 2.
Apology, I have one prayer, Lordship.
Hmm.
Item number 20, it has been timed in, Lordship. So I will see in my phone.
You
Okay,
can
I
leave.
will
We have your affidavit on record.
Lordship.
We will consider that. You can leave. We'll not trouble you. You can leave. I'll record your name.
Lordship, obliged.
Item number 20.
May I make a prayer, mention item number 5, my lord? Item number 5, my lord, the petitioner want to withdraw this petition, my lord.
So withdraw.
Withdraw, my lord.
Okay, 2 o'clock we'll pass the line. Item number 5, withdraw. That was a big.
My lord, on item 43, my lord, my junior will place the instruction, my lord.
Please, you can, if you have something urgency, please leave.
My lord.
No problem. That leave lifetime areas.
Yes.
2 o'clock. after the vacations, if you can accommodate me for that.
No worries, my lord.
Because 2 weeks motion day and this, it will not be possible, then the vacations. We'll have it on reopening. I'm keeping it for hearing only, but I will deliver the order on the next day.
My lord, kindly keep it as a CAB and deliver the judgment instead of hearing.
CAV, I will not do that. It never come out. It's headache. It's better to deliver here only. Now the
Correct.
matters are moving, mine.
Right, my lord.
Third day.
Going by the interactions we had there, my friend Mr. Tara will be more interested in early disposal. I should not be interested in early disposal.
No. Those, whatever discussions are there, Mr. Majumdar, those are only tentative.
My lord, Mujumdar sir is always playing with the double-edged sword. He can, making it as a Damocles
That means
sword
you don't
hanging
know
on the
Mr.
hands.
Majumdar very well. That means. Be very careful.
No, my lord, we understands our lines.
Heard. Yeah, say it. Also, the parties have been heard at length. Also, raised it to list this matter again on 17/7/2024 for delivery of orders.
Grateful, my lord.
Thank you.
All right.
Item 44.
Yes.
I don't, our affidavit will be received this week. We have made contention that, first of all, my lord, there is no order of regularization in the name of governor at least, because if any order of regularization has to be there, it has to be in that 2005.
Just tell me whether it is against a personal post or against a regular post.
If that is done, my lord, then it is against a personal post, my lord. So both ways, my lord, there is no scope for relief, my lord. But it is coming up, yes. That's coming.
Okay, after some time, let Mr. Chaudhary.
Item 31.
Yes. Madam Soma, what is it? Why are you not promoting them?
Lordship, the petitioners are otherwise eligible for promotion, Lordship. Only thing, Lordship may, there were a series of writ petitions, Lordship, before this honorable court.
Seeking relaxation.
Yes, they had sought the direction to the respondent authorities to consider the case for promotion to the next post of labor inspector by relaxation of the upper age limit of 45 years. And those representations, the Honorable High Court had granted them the liberty to make representation to each petitioner, to make representation to consider the cases. And the Lordship, thereafter the case was pending before the personal department. Only yesterday I have received this instruction that the personal department, Lordship, has no objection to consider the cases for the relaxation of the upper age limit and thereafter amend the service rules also. That is why, Lordship, their cases were pending.
So, my lord, that cannot make us wait, because if your lordship comes to annexure
How many posts are there?
19, my lord. And we,
Vacant posts.
Yes, my lord.
And how many are you there?
8 petitioners there, my lord, before my lord. So our consideration may come up, our DP may be held, my lord. There is no point in denying us our promotional benefits for long.
Okay.
DPC may be convened, Lordship.
Okay,
and
done.
may be considered.
Heard Mr. R. Sharma, Learned Counsel for the Senior Counsel, assisted by P. Fukan, Learned Counsel for the petitioner. Also heard Mr. Miss B. Sharma, U. Sharma, U. Sharma. I call her Babi Sharma. U. Sharma, Learned Government Advocate, appearing for the respondents. Also, the petition is by way of instituting the present proceeding has prayed for a direction upon the respondent authorities to consider their case for promotion to the post of labor inspector on being eligible, on achieving achieving the eligibility mandated for such promotion under the provisions of the Assam Labor Service Rules 2007. Also, the petitioners herein were initially appointed as
Ministerial staff.
ministerial staff both at the headquarter and at the district level offices. Also, the petitioners have in the meantime completed more than 10 years of service in such capacity, and accordingly they contend that they are eligible for being considered for promotion to the next higher post of labor inspector.
Labor-
You are appointed as
We are all ministerial staff. Annexure 2 will throw light on this at page 14. This is the recommendation by the Labour Commissioner to the government, and the list is annexed here with my lord.
okay. Full stop. Appointed as ministerial staff. Full stop. The provisions of the rules of 2007 for the regulating the promotion to the regulating the promotion from the cadre of ministerial government servants of the Labour Commissioner establishment and other ministerial subordinate staff of the subordinate officers under the Labour Commissioner Assam is governed by the provisions of Rule 6 of the said rules of 2007. The manner of promotion to the rank of Labour Inspector is governed by the provisions of Rule 6 of the rules of 2007. Full stop. The provisions of Rule 6, Sub-Rule 6, Sub-Rule 6A of Rule 6, right? Sub-Rule 6A of Rule 6 being relevant is extracted here in middle. Page 12, A to A. Full stop. A perusal of the provisions of Sub-Rule 6A of Rule 6 would go to reveal that 35% posts in the cadre of Inspector of
Labour Inspector.
Labour Inspector is to be filled up by promotion in accordance with Rule 7 by maintaining a ratio of 50:50 from amongst the ministerial staff in the office establishment of the Labour Commissioner and other ministerial staff in the subordinate offices under the Labour Commissioner Assam, who have rendered 10 years of service and have not crossed 45 years of age as on the date or as on the 1st of January of the year when such promotion is considered. So the petitioners herein construe that they have completed 10 years of service and have not crossed the age of 45 years, and accordingly they are eligible to be so considered. However, their cases were not so considered and the respondent authorities have not convened a DPC in the matter.
May I, my lord? My lord, at Annexure 2, my lord, we have already been recommended by the Labour Commissioner.
That is nothing. The DPC has to come in. Full stop. Ms. U. Sharma, Mr. R. Sharma, Learned Senior Counsel, has reiterated the above facts and has submitted that the non-consideration of the cases of the petitioners for promotion to the post of Labour Inspector has the effect of violating their fundamental rights, and accordingly he submits that a direction be issued upon the respondent authorities to convene a DPC for considering the cases of the petitioners herein in terms of the provisions in this connection available in the rules of 2007. Ms. U. Sharma, Learned Government Advocate, on instructions have submitted that the petitioners herein, although eligible for being considered for promotion to the cadre of Labour Inspector, their cases were not so considered on account of the fact that persons working in the ministerial cadre, both in the Labour Commissioner's establishment and in the subordinate offices under the Labour Commissioner, had approached this court by way of instituting writ petitions praying for a direction upon the respondent authorities for relaxation of the criteria of 45 years, and inasmuch as they all had crossed the upper age limit of 45 years. Ms. Sharma has submitted that that the representations filed by the said employees being considered by the respondent authorities, a delay had occasioned in considering the cases of the petitioner's hearing. Also, in view of the above position and it not being disputed that the petitioner's hearing fulfilled the eligibility criteria as mandated under the provisions of the rules of 2007 for being considered for promotion to the cadre of labor inspector, the non-consideration of the cases of the petitioners have the effect of violating their fundamental rights, and accordingly, this position cannot be permitted to be continued with. Also, in view of the above, the respondent authorities, more particularly the respondent number 3 and 4, are directed to convene a departmental promotion committee meeting for consideration of the cases of the eligible incumbents in the feeder cadres for promotion to the post of labor inspector, and accordingly, labor feeder cadres, including the petitioners herein, for promotion to the cadre of labor inspector, and on such consideration being made strictly in accordance with the provisions of the rules of 2007 to publish a select list for effecting such promotion. Also, in the event the petitioners herein are found eligible for being recommended by the Departmental Promotion Committee for such promotion, the petitioners be promoted to the cadre of labor inspector. The said exercise now required to be carried out by the respondent authorities shall be initiated and concluded within a period of 2 months from the date of receipt of the sorry.
And 1 month. It means already under process, so 1 month. Oh,
Oh, 1 month.
1 month.
Mr. Sharma asking and should 1 month.
very grateful.
I have like.
Item 44, supplementary.
No, it's okay, Mr. Mr. Chaudhary, Mr. Bhattakur submits that he will file the affidavit by Wednesday. We'll have this matter on Thursday. Huh?
So only before that one is just my lord.
I only want a clarification on that
Yes,
point.
my only, you will kindly have a look at paragraph 3, my lord, just
Okay.
paragraph 3. Page 6. Paragraph 3, man. Or page 7. So he was born in regular on 1/12/2003, man. Petition number 1. And petition number 2 is, of course, with effect on 22/7/25. 2005, my. And other one is, my lord, again, 1/12/2003. So 1 and 3, my lord, prior to that here.
No, if there is somebody who has been brought and regularized against a post in the regular establishment, will not prevent their consideration.
I have given that, my
No.
just.
Will not prevent their consideration, Mr. Bhattakur. But if they are against personal post, then Dilip Talukdar will kick it. Wednesday?
We have paid for some more time.
Thursday. Thursday. You have only paid for time. I am giving you a day. Thursday.
Mine, yes.
Thursday. Mr. I. Bhattakur, I heard Mr. H.R. Chaudhary, Learned Senior Counsel. Also heard Mr. I. Bhattakur, Learned Counsel, Standing Counsel. What is it? Public Health Engineering, appearing for the respondents. Mr. Bhattakur submits that the affidavits of the respondents represented by him would be filed on or before 19/6/2025. First up, accordingly, a registry to list this matter again on 24/6/2025. On 24th, we will consider.
Okay.
But
Item
Mr.
43.
Bhattakur kindly clarify this matter with documents.
43.
Yes, madam, instructions. 43 is applicable. Admission taking mainly so. It was the Bakini, Paula Hilutu. You have that similar order with you?
My lord.
Have a similar order?
My
Where
lord.
that period from the date of appointment is to be taken?
My lord.
My orders are there.
Fazli Rabli, my lord.
Ah,
It is
Fazli.
covered. Division bench of.
No. My orders are there. Okay, we'll pass the order.
My lord.
So this is the case that you were
Initially appointed with 1960, my lord.
1960, received scale
Okay.
81, retired
81.
on 98,
My lord.
died on so and so, net qualifying service. Madam, you'll have to consider it from 1960 itself in terms of that
No.
1991 Act, 1999 Act.
99.
Disposed of.
My lord.
But you'll get it on next week only.
Obliged.
Item 45.
Wait, please, your lordship.
Yes, who is for the private respondent? You are there. Okay. Yes, what is your case?
Lordship, my senior is actually out of station, your lordship. Therefore, I seek an adjournment.
You could have circulated a memo yesterday.
Lordship, it was a last moment decision, your lordship. I'm extremely sorry.
What is your case? Why his promotion required to be reverted? He is required to be reverted. Why? You reverted. You are APDCL. You reverted. You tell me why. This is an independent school. You appear the students high school.
High school, your lordship.
You this APDCL itself holds the matriculation examination. Who is aware? What is your case, madam?
As per the interstate seniority list, I am.
You mean you have filed an affidavit that the promotion should be on the basis of the interstate? Where is the rule?
Lordship, we don't have the rule, but Lordship may.
Mr. Counsel, this ground will not hold. You will have to develop.
Lordship, take a page number 63, Lordship, wherein it is clearly stated that the existing promotion rules followed by APDCL for promoting assistant teacher to assistant headmaster positions are based on seniority.
Where?
Page number 63 of affidavit in opposition.
Internal page. It's an annexure.
Yes, Lordship.
Annexure number?
Annexure number 11.
Huh?
11.
9, 10, 11. Huh? You have challenged the reversion.
Indeed, lordship, we have challenged the basic reversal because we were not heard in person.
Fine. But we'll also have to examine whether your promotion was proper.
Indeed, sir.
They say seniority. Be it not required. That's why I asked the question whether this school, the APDCL itself holds the examination or it is under SEBA.
We are also not aware about the same. Sir.
Mr. Counsel, can APDCL hold the examination?
No,
It
no.
will be under SEBA.
No.
If it is under SEBA, it is under NCT. Why have you not made pleadings to that effect? That NCT norms require the headmaster to be a
So, PH.
B.Ed degree holder. Finished. Why so much of headache? Heard the Lanark Council for the parties. The Lanark Council for the petitioner submits that the arguing council is out of station and accordingly prays that the matter be adjourned today. I got prayer accepted, raised it to list this matter after 4 weeks on a date to be allowed. I was ready to allow the petition for you today.
Could the matter be taken up before vacation, Lordship, because there's urgency, because at
Madam,
present,
you don't have a case. At least before this court.
Lordship,
You don't have a B.Ed degree.
Lordship,
NCT norms is applicable to all schools. It requires. Yes, Mr. Sisti. NCT, forget your provincialization rules. NCT headmaster B.Ed is must. Madam, your case is finished there. Unfortunately.
Lordship, may I hear it possible, because at present I am 59, Lordship, and I'll superannuate within 1 year.
Okay. Raised it to list this matter again on 23/6/2025. But madam, I'm sorry. If you can get something to counter this, get it. I'm with you. But otherwise, you get the NCT norms. You have not even made a pleading to that effect.
Item 46.
Meet legal lawsuits. There is an order passed by this earlier court. Yes, let's do non-effective.
Yes, Mr. Katonia, why are you not giving that
Yes.
registration? Have you applied?
Yes, my lord.
DSC.
Yes, my lord. This is that they have been, this time they have inactive. Earlier also they were okay.
No, they have given a reason that they can give this only from the provisional registration from DSC, followed by provisional registration affiliation by the new board. Why are you not giving? What is your instruction?
Instruction, specific instruction, my lord, I could not have my today, my lord. Madam, it fixed on Wednesday. On that day, I will produce the. In fact, I have got a report.
Wednesday board only. Friday code. Friday.
Yes, ma'am.
On the prayer of Mr. N.J. Khatania, Lanark Council for the petitioner, who submits that he be granted time till 26/2025 to complete his instructions in the matter. So, prayer accepted. Raised it to list this matter again on 26/2025.
Applies.
Just give that,
Yes,
because that is the only hurdle pointed out by Mr. Sutia.
Yeah.
My lord, this honorable court has already been passed the order to reopen the portal. My
That
lord.
was the interim order. You
No,
don't register, they will not
No,
give you.
next-
You don't register, why should they give you?
No, that is not the case.
Yes,
I
that
will,
is
yes,
the
my lord, on 20. Oblige.
Item 32 for orders.
My lord, despite the direction of the honorable court, my lord, they have not released the arrears salary. Even, my lord, from March 2025, they have released part payment as monthly salary.
Kindly take it after some time.
After some time.
Item 33.
May I please, your lordship? Lordship, on last occasion, we were directed to take steps. Steps are taken. And this honorable court also directed to take the present the
there in SLP, Lordship, pending.
SLP case numbers.
What will I do with the SLP? The SLP is disposed of. Where is the order? That same matter, Sanskrit teacher.
Lordship, this is music teacher.
Music teacher matter is pending in
Pending.
Supreme Court. Okay. It is submitted at the bar that. Where is that order?
This one is a SLP case number, dear lord.
That the issue involved in the present petition is under consideration of the Honorable Supreme Court in SLP number 30099/2024. So, in view of the above position, raised it to list this matter after disposal of the said special leave petition special leave to petition pending before the Honorable Supreme Court. Parties are at liberty to move an application before the registry for listing of the present matter after disposal of the said SLP by the Honorable Supreme Court.
Obliged.
Item 34.
এইখিনি ওপৰখিনি মই দি দিম, তলৰখিনি বিকাশত এটা আছে আপুনি দি দিব। এই যিটো অৰ্ডাৰ ওপৰখিনি মই দি দিম, বাকীখিনি বিকাশত আছে চিমিলাৰ বিকাশ মোৰ বিকাশত হা Yes.
My lord, this is the compassionate ground appointment. So he was listed for 3 times. He applied within 1 year. Due to his father died in harness.
When?
He was a headmaster
When?
in the year 2014.
14. Okay. When was your case first time considered?
First time. Annexation number 7, page number. Consider case of case.
No, DLC.
Next program of the. Annexation 10, page number.
23, 24. 23, 24. 26 is the original. Then second one is page 28.
Page number 20.
Thereafter, page 30. Yes, Mr. Counsel. What is your submission?
My submission that she may be appointed on completion ground as she is educated, unemployed, BA pass. Have no employed yet. She is facing financial crisis due to the none of the earning members in her family. So as there is provision that if anybody died in harness, his next of kin is qualified. She or he may be appointed on completion of ground. But yet, having qualification and applied for several times and was selected several times in the minute, but yet not appointed.
This last consideration by the DLC was on 15/5/2017. You are in need of a job. Why did you wait till 22?
In 2017, another presentation was submitted by the applicant, but that was not considered. In the meantime, Corona had appeared.
Corona came much later, 3 years later. How did you survive for 3
He
years?
second time applied, but she the office of the respondent was giving date by date that he will be appointed later on. He will be appointed.
Okay. I think you should stick to the officer's thing rather than coming to this court. Because we are bound by law, by decisions of the Supreme Court. Yes, Mr. Talukdar, anything to add?
Recently, your lordship was, that reference to the report of your husband, my lord.
I'm sorry. We can't accept your plea. Shall I pass the orders? Heard, Mr.
It's Bhuya.
H. Bhuyan, learned counsel for the petitioner, also heard Ms. K. Fukant, learned counsel appearing for the, Mr. B. Talukdar, learned counsel, standing counsel, school education department, appearing for the respondent number 1, 3, 4, 5. Also heard Ms. K. Fukant, learned counsel, appearing for the respondent number 2. Also, the petitioner, by way of instituting the present proceeding, has prayed for a direction upon the respondent authorities for consideration of his case on compassionate grounds for appointment as assistant teacher on compassionate grounds. Also, as projected in the petition, the father of the petitioner had died in harness on 8/6/2014 while serving as the head teacher of Telia Ohuar Balika LP School. Also, the petitioner, pursuant to the petitioner draft, submitted an application before the concerned authorities for being extended with appointment on compassionate grounds. Also, the application as submitted by the petitioner was considered by the jurisdictional district level committee in its meeting held on 9/1/2015. Also, the committee, on considering the case of the petitioner, did not recommend his case for appointment on compassionate grounds on account of the fact that there was no vacant post available for the same. Also, the case of the petitioner was again considered by the district level committee in its meeting held on 26/9/2016. Also, again, on consideration of the case of the petitioner, there being no vacancy available for appointing him within the 5% quota mentioned. 5% quota mentioned for appointment on compassionate grounds in the establishment concerned, the case of the petitioner also again came to be rejected by on the ground of non-availability of vacancy. Also, thereafter, the case of the petitioner was again considered by the DLC in its meeting held on 15/5/2017, and hearing noticing that the period of 2 years had elapsed and the case of the petitioner not being permissible to be recommended for appointment on compassionate grounds on account of lack of vacancy, the application of the petitioner was held to be time lapsed. Also, the present writ petition was filed thereafter only in the month, only on 7/12/2022. Also, it is seen from the materials brought on record that the case of the petitioner was duly considered by the jurisdictional district level committee, and the reason for non-recommending the name of the petitioner was that there was no vacancy available within the quota mandate prescribed for appointment on compassionate grounds in the establishment concerned. Also, on consideration of the materials brought on record and upon hearing the learned counsel for the parties, this court is of the considered view that given the fact that the father of the petitioner had considered view that the petitioner's case was duly considered by the respondent authorities in accordance with this scheme in place at the relevant point of time, and accordingly no error in not recommending the case of the petitioner is discernible from the materials available. Also, accordingly, further, it is to be noted that the petitioner in the present proceeding has prayed for a direction upon the respondent authorities to consider his case for appointment on compassionate grounds as assistant teacher. Such consideration is now being called to be made by this court after around 11 years from the date of death of his father. The Honorable Baki এখানে আছে আপনার কমিটি এখানে তো দেবব্রত তিওয়ারি dismissed.
Item 32.
Yes, Mr. Sugya.
Yes, I am appealing for the contemners.
Hmm.
Although the education department has prepared the proposal to the finance department for clearing up the views, we have come with some very startling facts.
Hmm.
And by finding those facts, we have filed a review also. That was filed on 13th. So I am praying for.
Oh, you have already filed a
Yes,
review against that
already,
order
yes.
before the learned Singh
Yes,
other one.
Yes,
Okay.
Lord, it's on 13th we have filed it. So I am praying for adjournment of this case for 4 weeks.
Okay.
Because when the.
No, if you have taken some steps,
Yes,
Mr. Sugya, we are the last
And
person to come in.
division bench also did not consider those two very vital facts. One is that.
But one factor I found that you have somewhere mentioned that his appointment was not in the manner required. What
That is one
happened
part.
is,
That is very.
no. Then what you have done is, you have also moved an application for creation of a supernumerary post.
Everything we are doing, we are hand in glove with him,
Hmm.
some of our persons. Now the problem is that when he appeared for the examination for recruitment at that point of time, he was 15 years old, number one. And the school in which he was appointed, that school was never in existence.
Heard Mr. A. Gouin, Learned Counsel for Deputation. Also heard Mr. D. Saikia, Learned Advocate General, appearing for the state. You can appear as an advocate.
Yes, no problem.
Advocate
In
appearing for the
1965, one full constitutional judgment of Supreme Court has laid down the law
That-
on it.
appearing for the respondents. Mr. Saikia has submitted that when the matter was being considered for implementation of the directions passed by this court, vide the order dated 31/3/2016, certain facts which would go to render the initial appointment of the petitioner to be void had come to the notice of the departmental authorities, and accordingly, the departmental authorities have filed a review petition against the said order dated 31/3/2016, passed by this court in WPC number 2276/2011. The said review petition has been registered as review petition number, filing number, has been filed with filing
Very
number
long number also, and giving a copy of this.
7588/2025. Full stop. In view of the above position, this court is of the considered view that the present consideration of the present contempt petition stands adjourned for 4 weeks, enabling the respondents to proceed with the review petition. Full stop. On the next date of listing, Mr. N.J. Khatonia, Learned Counsel, assisting Mr. D. Saikia, Advocate General, shall apprise this court about the outcome of the said review petition.
Highly obliged.
Mr. Gohai, wait, let's see what happens.
Item 35.
My pleasure also. In this case, I have filed one IA for striking out the name of the respondent.
We'll strike that off at our own script.
I will-
But tell me about the mail.
Yes, Lordship.
What is the error? See, you have a physically handicapped certificate.
Yes, Lord.
Therein certain percentages given. Now the respondents examine, found that you are not having that. But they did not deny you the appointment. What they have done is, they have now with this finding, directed that the matter be placed before the certificate issuing authority. What mistake happened?
Yes, Lordship.
What error has been committed?
So now the petitioner number 2 is already appeared before the re-examination authority, and he is found that his PWD category is above 40%. And Lordship, and he is eligible for appointment as per the.
Okay, what about the others?
Others, Lordship, petitioner number. Petitioner number.
How many
4.
petitioners are there?
Now, Lordship 3, petitioner number earlier, Sima Huya is already staff of. Now, the petitioner number 1 is appeared for your Lordship for striking out his name. And remain Lordship 2 and 4, that is Vinod Setri already is Lordship, as per the examination authority, he is already eligible for appointment. Now,
And Bipai Sorgiari?
Bappi Sargari yet to be appeared before the re-examination authority.
Where is the material with regard to their reappearance and the orders?
filed their affidavit.
There
stating
it,
that-
nothing is there.
Stating that if the disability percentage of the petitioner are found to be above 40% on re-verification by the executive authority of the disability certificate of the petitioner, then the
Where are you reading?
the affidavit filed by the respondent number 4.
Page
number 71.
71.
Yes, sir. Para 6 note.
Okay. Yes. Where is this report?
Also, but, also the verification is not, instruction was it, at, till date regarding this, petitioner, revision is not received. There are other petitioner, not petitioner, other person, the report has come and some person only,
What happened to these three petitioners? She says that 1 and 2 has already been has already been held to be above 40%.
that,
Madam, where is that material?
One is yet to be appeared, Lordship, but
Ah,
it's not
because-
no,
Why has he not appeared? He is not interested.
not interested.
Not interested. So we'll say that he is not interested. Huh? And
Striking out his name, saying that he's not. interested.
and we'll say that one is striking off or 3 is striking off.
Three is
Three already
already
struck
striking out.
Already struck off. And today you have filed an application for striking off
One
1. So only 2 is left.
depending.
We will say that we'll quote the submissions of the contention of the director and say that if in the re-verification report it's found to be above 40%, he'll be given the appointment.
But Lordship, Bhakti Sargari is not yet appeared, Lordship.
So it's already stuck off.
No, Lordship, petitioner number 4, Bhakti Sargari.
The only 3 petitioners are here before me.
Petitioner 1, Pranab Prasad and 2, Vinod Chetri and Bhakti Sargari.
3.
Yes, Lordship.
Uh,
So one, petitioner number 2, Lordship, that is Vinod Chetri. He is already appeared before the re-examination authority. And Bhakti Sargari is yet to be appeared, Lordship.
Why? Why has he not appeared?
Within 2 weeks, Lordship, he will be appeared.
No, that cannot be. There was a direction of this court. What was the direction? What was the time limit given?
There is no time limit. Lordship.
yes, yes. And, 3 months.
Yes.
But you have the health side, director of health services is not party to this, is the official responsible. But still, the Honorable High Court had given us, directed us to obtain instructions as to what action has been taken by the different joint directors of the different various districts.
Mm.
And as to whether any action report has been taken on behalf of the disabled candidates, which has been annexed in the IA, I believe, Lordship. That instructions, it is still awaited. As to what action taken.
As
has
prayed for by the Learning Council for the parties, raised it to list this matter on 23/7/2025. On the next date of listing, the Learning Council for the respondents shall apprise this court as to whether the process of verification in respect of the petitioners have been completed. Full stop. Oh, no, we have filed an IA, na?
It's not numbered. I have filing number.
Oh, you not numbered, huh? Verification report, so and so. Verification report with pertaining to their percentage of disability suffered by each of them. Full stop. Registered to list this matter again on Ivankulu 23/7/2025. You get us that.
Along with the IA.
You file, you
And
come.
one lead petition was, other lead petition was 6800, same matter. Lordship.
Same matter, same department,
Same-
along with WPC number 6,
6800,
6800,
2022.
2020.
Published.
Much of it.
36.
Who is appearing for the higher education department?
Lordship.
Why this has not been done?
No, Lordship, because lawsuit, is a place in DPC lawsuit.
The order is of 11/1/24.
That's true.
You take 1 year,
No,
1.5 year.
Lawsuit.
Hmm.
First of all, in contempt matter lawsuit, K. Gogoi and S. Das is appearing lawsuit.
I'm not
No, no, no,
concerned.
no,
If you have there any problem,
no.
we'll have the direct side.
I talked to S. Das lawsuit.
I want to know what is
Yes, no,
happening
but because
after half an hour.
DPC
2 years, this order is not complied with. What is this?
because DPC is not sitting lawsuit.
Why? Any problem of the members? Can't sit.
No,
Then?
that's
Sitting problem. I want a reason. This is violation. Clear cut violation. Raised it to list this matter again on 23.
Yes, Lord.
23/6/2024, on the which date the learned counsel representing the respondents shall apprise this court as to the steps taken by the respondents for compliance of the directions passed by this court wide order dated 11/1/2024 in WPC number 6887/2023.
37.
All orders, one line
Yes.
thing, you are not doing it.
So,
Even?
Family pension of the petitioner, my lord,
Yeah, that was forwarded.
You have done your job. Who is appearing for the, but you have not implemented the director of pensions.
My lord, it is the DI of school who has to submit the proposal.
It has already been submitted.
No, my lord, he has submitted wrong proposal, my lord, and kindly see, my lord. Rather, he is not aware about section 143, rule 143, or in my lord, apparently violated. Our honorable court, my lord, clearly stated that you submit according to rule 143.
Please, you are putting to work.
And he himself mentioned about the content case and the writ petition. So he is not aware, it is not a thing, he is not aware. My lord, 74-year-old, my lord, he is not properly see the things, my lord, and properly, not my lord.
It is stated in the bar that the pension proposal in respect of the petitioner was submitted by the Deputy Inspector of Schools, Srimanto Hankordev Nagar, Hussain, Assam, in pursuance to the directions passed by this court wide order dated 2/2/2024 in WPC number 3932/2017. However, the said proposal was sent back by the remitted by the Director of Pension to the Deputy Inspector of Schools, Hussain, on account of certain lacuna being detected therein. Also, the DI of Schools, Hussain, was required to rectify the lacuna and to resubmit a fresh pension proposal. Also, on the next date of listing, Mr. Chisti shall receive instructions as to whether the
DI has requested the petitioner to submit.
I'll do that. I'll do that. Mr. Chisti shall receive instruction as to whether the fresh pension proposal after removal of the deficiencies noticed by the Director of Pension has been again sent by the Office of the Deputy Inspector of Schools, Hussain. Also, considering the nature of the deficiencies pointed out, the petitioner is also required to appear before the Deputy Inspector of Schools, Hussain, within a period of 7 days from today for rectification of the lacuna detected in the pension proposal submitted, by the Director of Pensions, and to submit the documents oblique photographs so required. Also, accordingly, raised it to list this matter again on 30/7/2025. Full stop. On the next date of listing, the Mr. Sisti shall apprise this court of the further developments taking place in the matter.
My lord, one major, my lord, mistake committed by them, my lord. They have submitted in favor of son. When the husband is like, my lord, can you see that in the proposal? So, my lord, in violation of.
Konkan Bodloy, who is Konkan Bodloy?
No, my lord, 143, Roman 3 says that.
This proposal is not submitted in the name of the
No,
spouse.
My lord, the name of.
What is the name of the spouse?
In order was directed in legal hair.
Haven't got the law.
Order was that they have to verify who is the legal hair.
No, it is already settled. Already settled, not only settled, my lord, honorable High Court order is there. There is one.
Oh, that case, your husband. No, rightly said.
Yeah.
I'm sorry, Mr. Chan, we are not accepting that. Oh, who are you?
Husband.
Baba. Okay, come to the order. We'll see what the violation is. You come to the order.
Yes. Court conclusion and observation, paragraph 18 and 19.
I'm sorry, you'll have to read 17 also.
Yes,
I forgot this, I'm sorry.
my lord.
You're not entitled to pension. Your case has already been held to be, you're not held to be a husband. You are declared not to be a husband.
No, not.
Yes,
No,
come,
but-
read.
No, not this. is-
Read.
Not the.
Read para 17. Okay.
My lord, thereafter, my lord, there is judgment of honorable, my lord, civil judge, senior division appeal, which is included in this here, my lord. I have.
Where?
The judgment page 9. Page 9. Judgment passed by Mufit, set aside. Appeal allowed.
Okay, your status as a husband was restored.
My lord, it's settled.
Okay.
Why
So while the DI schools, while forwarding the pension proposal, shall also keep in view the provisions of Rule 143 of the Assam Services Pension Rule 1969. Whoever gets it.
Yes,
It's up to him.
38.
I am dying. I was supposed to file your lawsuit.
You make your submission.
Sure.
Mr. Bora is very busy.
No.
You make your submissions.
No, they have not filed their affidavit.
Forget it. We have the office order before us. This order is of 29/7/24,
Okay.
directing that from 31/8/24, you will not be in service.
No.
Contractual agreement
No.
settled. You instituted this petition on 29/10 2024. That means after 2 months. By the time you came, you did not have a contract of service.
No,
How can we extend that?
No, you're not. We practice like this. Prior to this, we have filed a writ petition. During the writ petition, they have come up with your lordship saying that they have already appointed some people in those posts, your lordship. And in view of that, your lordship, we have filed a subsequent writ petition challenging their appointment.
In the earlier writ petition, was there any interim direction that
No,
you should not?
since your lordship, they have already said
Where is that writ petition?
that your lordship, last occasion, your lordship, that has been your lordship closed. Your lordship.
Why, how was it closed?
Because your lordship, since we have filed a consolidated writ petition here, your lordship. that's
Okay, now this is what we have to hear now.
Yes, sir. Now your lordship will
Now you
kindly
tell
see-
me Gritco and all those line of cases
Lordship.
which says that once a contractual engagement has come to an end, this court will not have a power to put you back.
Lordship,
You have a grievance,
I am not.
you can
prepared-
go before the
I-
specific relief act.
Your lordship will have to accommodate me for that, your lordship, today, your lordship. Today I am not prepared, your lordship. Otherwise, your lordship,
Okay.
I have two-fold grievance, your lordship. One, your lordship, the manner in which the private respondents were selected
That
without
is-
issuing
That,
advertisement.
that is a different, this is all contractual.
No, your lordship.
How
even-
were you selected?
Lordship,
How were you selected?
we were selected and your lordship pursuant to selection process. your
Show me that.
That, your lordship, I have not annexed that, your lordship, but my appointment orders I have annexed. Now, at the end of the day, your lordship,
And you have not said anywhere that you were in pursuance to a process of selection, given this appointment. You have not said anywhere.
that was not an issue, your lordship. That's the-
Now, any
No,
writ petition,
any-
anything can come up.
No, your lordship will kindly see, suppose your lordship, my appointment as contractual is not as per rule, your lordship. But that will not deprive me from.
This is nothing of a rule or not rule. The Supreme Court is very clear. If it is a contractual appointment, extension not given, contractual appointment comes to an end. After that date, if you come before this court, we cannot put you back.
Lordship cannot put us back, but your lordship is subsequent appointment, your lordship.
If I
which-
can't put you back, why should I go and,
Then your lordship, if that selection.
then you will have to show me that your selection,
No,
there was a advertisement, Mamata Mohanty was followed,
no, your
and
lord-
then you were appointed.
Your lordship will kindly see the moment your lordship, my contract goes, your lordship, I am out, your lordship. They decide to bring in someone else, your lordship. What I am praying, your lordship, I am praying that we should also be ought to have been provided an opportunity to.
Yes, why did you not provide them an
That-
opportunity?
let them come.
Oh, you also want instruction, then it's. As agreed to by both the as agreed to by the parties to the proceeding, this writ petition be listed in the month of September 2025 for admission hearing.
Lordship, September. will be-
They also want, you also
For
want,
them,
all are, this court is only interested to this. So we'll also relax.
in
August.
August.
But
So
Mr.
since it is an order column, your lordship, I thought that.
Order, it's hearing, anything is hearing.
Item 39.
But you examine this issue.
Lords.
10/6/24, the lordship's order, operative part of the case.
Nothing has been done.
Nothing. They were called for Miller, but records they Miller, Perus Miller, everything was asked for Miller. Page 17 Miller,
Who is appearing?
2824 Miller, all are.
Who is for the respondent?
Respondents, secondary education Miller, the council.
Somebody has entered it here.
39. 39.
Yes, Mr. Sisti.
Oh, yes, okay, file our affidavit, Vocal lordship.
Hmm. Why this is, you have taken it up on appeal?
So I couldn't go through it.
Mr. SMT Sisti submits that he be granted a week's time
Yes.
to complete his instruction in the matter. Raised it to list this matter again on 20. Hey, sir, give a party. 23. Next week to, yeah, motion date.
Item 40.
Same.
I need some clarification.
Mr. Sissi,
Yes. Only to place
just
before
read
the
that
SLC.
order.
Yes,
There is nothing.
nothing. Yes, to place before the SLC, I have seen.
That's-
it.
that much only.
I will get the instruction.
Same day,
The compliance order by
Same day,
next week,
same day, same.
on 23rd.
same day.
And the second, next case also.
2020, when have you placed it? 24.
23.
24.
20,
23rd,
23rd,
23.
yes.
huh?
and this one,
41.
41 or 23rd. Same. Similar.
I do same.
Yes.
Have you retired, Mr. Botpool?
I have.
No, so I found the order that last time
42.
some pension has been cleared and all.
Not in respect. I have not referred to it.
Mr. Chisti had submitted. Order in question has already been complied
No,
with and the necessary.
your lordship, kindly see the order. What they did, your lordship has directed to conduct the review selection within 3 months.
Hmm.
Now, after all these months, your lordship, they have passed a speaking order saying that we will conduct a review selection.
But we
How
have,
can it be complied, your
but we have
lordship? Don't
recorded
consider
that
it
private
complied?
respondent lawsuit.
That you will have to.
Next one is yet to be done.
That you will have to.
Yeah, but
There is a
I have seen
direction.
that selection, but that is what I have questioned my director lawyer.
The director questioning will not do. When will you schedule it? Tell me.
That selection part has to be.
That has to be. You have not taken it up on appeal?
No,
I think
your
not.
No appeal then?
But the private respondent, he was already recorded back.
We are not concerned. We want our full compliance of the orders.
Yes, that is what
I left it to you. I did not do anything. I left it to you. Now when? How long will you take? Only a convening is required. This will be in the school level.
Lord, I think it is in the school.
Huh,
Selection
we will
committee-
have it on
school selection
25th. You give me the order of convening of DPC.
convening. Yes,
Mr.
yes.
I'm not asking
Yes.
you to hold the DPC, but
Lord,
convene it
yes,
and
yes,
hold it.
Yes, yes.
Mr. SMT submits that the respondent authorities are processing the matter for compliance of the directions passed by this court.
One
Wide
part
the
complied.
order.
There's also direction to regard that private respondent. That part is complied.
Okay, fine, fine. For implementation of all the directions passed by this court, wide the order, judgment and order dated 6/9/2024 in WPC number 2776/2020. Oh, sorry, he submits that he would place before this court on the next date of listing, the developments taking place in this connection. Oh, sorry. Registry to list this matter again on 25/6/2027.
Yes, applied.
Just get that order
Yes.
directing that we have now
Yes.
convened the meeting.
That's what
That's
I've
all.
already asked them.
You do that. We'll go step by step, no problem. Leftovers, madam.
Time being item 1.
Yes, Mr. Abedi. Ready. Because the person, listen to the question. Yes.
Here is a case. In respect of a grade 4 post of a provincialized school. School is provincialized. The respondent number 9's father was working in that school. In the year 2005, what the problem has occurred? An advertisement was issued. A specific advertisement was issued to all the head of the institutions as well as the districts, saying that you call for the interview or you call to issue an advertisement and call for the applications last date 31/12/2005.
At that time, respondent number 9's father was in school working. So question of that post being vacant does not arise. So no such advertisement was needed from that school at all. Incidentally, in the beginning of 2006, respondent 9's father expired. He was asked to work in that school by the managing committee, and they will process this matter. But as he, for some days he came, and after that he stopped. Then in the year 2013, as there was no, well, after 2005, there was no such guideline or instruction from the authority to go for a fresh appointment. So school required a grade 4 employee. So the SMC, they asked the petitioner present before
Okay,
my lord.
Mr. Abhinay, I got your point. Your point is basically when there was no vacancy, how could an advertisement be? And any selection made in persons therefore is void ab initio. That's your case.
Yes.
And you also agree it's not an appointment on compassionate grounds. They had made a mistake there. It was an appointment in terms of that selection.
Followed over there, I have to say only one thing,
No.
as your lordship is looking at the case now.
Can I not
Yes,
look
sir.
somewhere else? I
No, no,
can't
no.
look, I'll have to look into the case only. No. I can't look somewhere else.
My lord, if it was a compassionate,
No.
to an extent, it would have gone in a different direction.
It's not a compassion.
But if it is not,
We'll not, no, we'll not go into that.
Oh, sorry. Then, my lord, what the affidavit in opposition of the respondent number 9 says, that it was from a selection. The selection could not be done.
Because there was no vacancy.
There was no vacancy.
Okay.
But what he says, that in 2006, a letter from the
Now,
district authority came before the school.
I got it. I have asked this question to Mr. Pukaisto in the morning. Because you were missing. Yes, naturally.
No, I was in court.
No, you're busy, man, I know that. There's no issue, no problem with you. But now come to page 124. This is a writ petition filed by the respondent number 9. And this court had directed the respondent authorities to act in a particular manner. Now they have acted in that particular manner, resulting in an order of appointment being issued in this case. Right? Resulting in an order of appointment being issued in this case. Now this order standing,
No, what I'm saying,
can I go beyond?
no, your lordship. My lord, realizing this order is there, what I'm saying, when the state level selection committee sat for the first time,
It did not give any credence to his application. Then we are not selecting.
and further, in that list of selected candidates,
He was not there.
he was not there, actually. And
That is
only-
why he came up before.
No, my lord, only one thing. Subsequent repetition and that emerging with the right. Only thing is before my lord. If my lord accepts that, I'm in, otherwise I'm out.
Only thing, take me out of this 2011-2019. You have not challenged this. So the effect of this order is anything that was there prior to this stands condoned.
But your lordship,
You are saved by this order. Subject to he finding out something. Seems that your junior associate has ditched you. He's gone away. Mr. Vinay?
my lord,
He seems to have parted ways with you.
It seems, my lord, I don't know why.
He understands, he knows the matter better. So, Vinit, take your breath. We'll have it after 10 minutes. You go through, you get your instructions. Next. You get your instructions.
Item 3 and 4.
And Mr. Professor, give me an answer to that also. Yes.
Sorry, lost I even like at that point of time.
What are you doing with the two ladies?
Lordship,
Why
actually-
are they
Actually,
treated in
we have
this-
done our part.
No, you have not done your part. Why are you treating them? Why are you giving them hope if you can't give them an appointment?
No, Lordship,
We are
actually,
going to impose cost now.
no, Lordship, actually, we are not giving any hope to. any-
Yes, you have given them
Thing is
hope.
that
You have engaged them on temporary basis on compassionate grounds.
Yes, sir.
There cannot be an appointment on
Exactly.
temporary basis. Regularize it. I don't know how. You do it. We are not going to follow the law. Two ladies destitute.
Exactly, Lordship. We are
And
having,
you put them to
Lordship, the
sort
authority-
now.
exactly, Lordship. The authorities are having.
When
sympathy,
you want it?
Lordship,
When are
because,
you giving me the order?
because we have sent the proposal to the.
I don't know
government,
the
Lordship, because
proposal.
they-
This is an autonomous body. You take your call. How you do it. But these two ladies should not be put through so much of suffering.
Exactly, Lordship. We are having absolute sympathy for
I
them.
don't
And that
know.
is the reason why, Lordship, we have
When,
processed
Mr. Chaudhary? I'm giving you the,
after vacation.
you give me a date, but I want the orders on that. If we have to come in, we are going to impose cost. I'm telling you.
Some technical flaw is there.
I don't
that
know.
I can understand.
I don't know.
Fact
That
is that
technical
there
flaw
was no malafide
has
intention on the
given them, otherwise this was a case for outright rejection because of the delay in the compassionate appointment date. It was a delay. But now that you have appointed them on compassionate grounds, give them the full salary. Nothing, no middle way. When?
after vacation.
Give me a date.
First week of last.
I have forgotten weeks. I only want a date.
17th of July last week.
Mr. S.P. Chaudhary, Learned Council appearing for the Assam State Housing Board, no?
No, Lord. And for the Assam urban waters.
Urban water.
Urban water.
Yes.
So and so,
Number
so and so. You see that?
Water supply sewerage board.
Assam Urban Water Supply and Sewerage Board submits that the grievances of the petitioners would be considered for redressal by the board, and appropriate orders in this connection would be
There will
by.
be some difficulty with regard to that question. Because the process that has been initiated by the board, the subsequently it has been rejected by the government lordship. There is no laches, no delay on our part lordship. We have done our level best lordship to apprise the authorities to do whatever.
Who is the authority?
Lordship, this Secretary, Commissioner Secretary, Government of Assam Housing and Urban.
Yes.
That is what it is their own creation. He did so.
Now, who you have created, you reject, it's very easy.
No, your lord.
But what about these two ladies?
I have full sympathy, but the same.
There is not a sympathy, rightness accrued.
This board, they only appointed him without any kind of sanction from us. They did so.
Is it required?
Your lordship, at the time of regularization, or any kind of appointment in compassionate ground or anything for that matter, your lordship, they have to take extension from us. That's why.
Board has to take.
That's why they are taking sanction.
No,
with
no,
regards to
if
our
they
regular-
appoint within the sanction strength of their service, why your consent is required?
Your lordship, with regard to this compassionate appointment.
Mr. D. Bora and Mr. S.P. Chaudhary, Learned Council, representing the respondents, shall receive instructions as to why the appointment on compassionate grounds granted to the petitioners. There are two cases, no cases, 3 and 4 except now. Petitioners in the above noted petition was so not granted in the irregular scale of pay and against a regular post of registry to live this matter again on 77/22.
Next, second week after reopening.
21/7/20.
21/7.
As a pilot. As a pilot.
Wait. You want to hear it? Tell me, what is your right? I'll have to hear it then. So, you're doing something for you.
Yes, sir.
You don't have a case. It's only equity power that I'm using.
Item 5.
Otherwise, this case took me 2
Otherwise,
minutes to discuss,
I appreciate that.
especially the first one. Second one,
Is little bit.
there is something.
Abla-
You want to withdraw it?
My lord.
Mr.
what
B.K.
is
Das,
that?
London Council for the petitioner, on instruction submit that he be permitted to withdraw the present petition. Also, prayer is not objected to by the learned council for the respondents. Accordingly, the present with petition stands withdrawn.
Order may be.
Stands dismissed on withdrawal.
Interim order may be vacated.
Interim order, if any, stands vacated.
Item 7.
Mr. Roy, what is left here?
There is PL pending, my lord.
That is different thing altogether.
They have submitted. report.
Here, your thing is for making the report so and so public. Now it is public.
No, they have given us, there is one PL also pending. That is.
Mr. Roy, it was placed before the legislature.
No, I'm saying that, but
Huh.
the last time Lordship was there in the division bench, the matter has come up. The PL 45 of 2023, they have given one part of the report and second part they have not given, the court directed them to
That
give it.
whatever is there will be taken care in the PIL itself.
No, that's correct, my lord, but
Why two proceedings? For the same reason.
no, there is a PL or like this is sent to the PL.
I can't do it. This is an independent one.
That's what my.
That prayer, what you're seeking in the PIL is the same
Same
prayer.
thing, same thing.
Whatever happens with PIL so and so subject to that, we will close this. Because Mr. Roy, the matter was placed before the commission report was placed before the legislature. Can you get Mr. Dean up?
The teaching superior is looking after here.
Because Mr. Roy, this was placed before the legislature. Placed in the legislature.
Well, they have given the website, my lord.
Hmm.
And that's what I'm saying that.
The complete report is in the website.
They've given one part of the report only. The second part, then I informed to the division bench, my lord.
That will be taken care of in the division.
Then I told the division bench, my lord, that lordship, that report, the complete report, they have not analyzed. Then they took time to file affidavit, my lord. That was
Will
the
be made,
status of the
will
matter.
be issued for making the report of so and so regarding so and so to be made public. You get Mr. Nath. Senior government advocate,
Well, let it be tomorrow, my lord.
tomorrow. Oh,
Oh, tomorrow, I'm going out, my lord.
on the prayer of the learned council for the parties registry to list this matter again after 6 weeks on a date. You come back after the vacations, we'll see. Just, it is there.
Item 13. I want to withdraw the petition.
Your name?
M. Rahman, on behalf of NR.
Mr. M. Rahman, learned counsel appearing on behalf of Mr. N.
N.
Ahmed, learned counsel for the petitioner submits on instruction that the present petition be permitted to be withdrawn. Also, prayer is not objected to by the learned counsel for the respondents. Also, accordingly, in view of the above, the present petition stands dismissed on withdrawal.
Item 15.
Yes.
Like,
But Mr. Soikia,
my lord.
Operation successful, patient dead. Operation successful, patient dead. I can't do nothing because there is already a second selection. If you don't make a challenge to that, how can I? Who will do that? You withdraw this with liberty.
Can you keep it pending while we file a separate?
This I'm ready to allow, but allowing this would be futile exercise. Because the posts have already been filled up.
It was not filled up.
It is filled up.
Only, my lord, they have been forwarded, my lord. As per
There is
their-
no stay order.
No. Kindly peruse, my lord.
Yes, as the press, no.
And
Yeah, it
except
has
three,
been
page
filled up. There is
54,
a, there is a affidavit,
page 54, my.
38, page 38.
My.
You come to the second paragraph, last two lines.
And accordingly, the engagement letters were issued to all the approved candidates and they joined their duties. Now you'll also kindly page my lord 54.
50?
Page 54, paragraph 3.
Hmm.
Only approval is there, my lord.
Oh, this is after that. This is
My lord.
necessary engagement while this letter office notice dated 10/8. It should be after this only. Anyway,
Since my lord, no order has been, my lord, annex would be, my lord, affidavit. no.
that is a different thing altogether. But if the
Therefore,
post,
my
there
lord,
are
therefore,
some
my
other
lord,
person,
keep it pending, my lord, I will file.
Mr. PJ Sekia submits, London Council for the petition submits that the respondents have filed an affidavit of the matter, and accordingly, he would receive his instructions thereof from the petition. Prayer, he accordingly prays for an adjournment in the matter. The prayer is not objected to by the learning for the respondent. Accordingly, he raised it to this matter again after 4 weeks on the date. But take up this.
I'll see.
Item 18.
None appears for the petitioner even on second call. Mr. B. Chakraborty, Learned Counsel for the petition, Learned Citizens, hearing for the respondents. So accordingly, the petition stands dismissed for non-prosecution. Nothing is there also.
Item 20. 2014 order challenge.
Item given. There is only one matter or two similar matters?
Lordship may help otherwise, but today I'm not feeling well, madam. That is why Lordship may take the matter some other day, madam.
Okay.
This
But
otherwise,
Mr. B. Chetwick, Learned Counsel for the petitioner, also heard, madam, your name? I Kotoki for respondent? Oh, from M Kotoki, okay. We'll write M Kotoki, also heard as M Kotoki, Learned Standing Counsel, Animal Husbandry and Veterinary Department. What's up, Mr. Chetwick, summons that the matter be not taken up today. And we fixed on the matter, praise that the matter be adjourned today as he. No, adjourned today. Put so, where is not objected to by the Learned Council for the response. Accordingly, the raised it to this matter again on 23/6/2022.
I'm sorry, madam.
Alright. When you are sick, this is the last quarter to insist. Otherwise, I'll insist.
Yeah.
Item 47 for hearing.
But it's okay. Where is your? Mr. Gosam, J.K. Gosam, the additional senior government advocate, has submitted his written arguments in the matter. Gosam, the same is taken on by Gosam. Accordingly, the hearing in the matter is concluded. The registry to list those matters again on 100%. Not like it. When I then ordered it by 22/7 for delivery. True. One person, yes. Forgot to, yes.
My lord, Day after tomorrow.
No, today.
Okay.
Day after tomorrow, again, morning you will be missing. I'll have to wait the whole day to see you.
Actually, I had a case, motion case somewhere else.
Okay. On the prayer of Mr. J. Abedin, Learned Counsel for the petition, registry to list this matter again on Wednesday by slip quitting for further hearing. You give me that answer.
Deeply obliged.